Please be seated. Record will reflect we're in session on State v. Fleischauer. Mr. Burton is on the stand. I'll remind you still under oath. And Mr. Kaiser, your continued cross, please.
Thank you, Your Honor. Mr. Burton, I think we stopped where I was asking you whether or not Exhibit .325, your report, was dated December 9th of 2019. Is that correct?
That's correct.
All right. Now, the static cuneiform firearms testing apparatus, that was a thing you built, is that correct?
That is.
And that's a name you gave to it?
I built it, I named it.
Do you remember how much it weighed?
I did not weigh.
How tall was it?
5 feet 11 inches.
What was the head made out of?
The head was made out of bullet-resistant acrylic or Lexan with a 1/8 inch metal backing.
Where was that?
Excuse me?
You said metal backing?
The metal backing was on the back of the head.
Okay, that's what I want to know. Was that so when it fired, the bullet that fired would hit that backing?
If any of the bullet-resistant material that the bullet was being fired into penetrated that material, it would terminate at the backing.
The pistol that you used was being held by I'm trying to find where it said the pistol was being held by a piece of foam from the insert of a knee pad, is that correct?
That's correct.
And what was the Velcro strap strapping it to?
It cradled the grip of the gun just to provide a secure grip on that grip.
So if a person were to put this semi-automatic handgun into their hand, is there a portion of the back of the gun that has a name that hits where the web of our hand is between the forefinger and the thumb?
It's generally referred to as the beaver tail grip, part of the beaver tail part of the grip.
So was there anywhere in your video recording that we saw that showed us how the pistol rested up against the knee pad and the strap?
There was no close-up detail of that.
Would you dispute that as we looked at that video that it appeared we could see almost the entire handle of the pistol up to that place that would normally hit the webbing of our space between our thumb and our forefinger?
It was loosely restrained.
Okay, but it wasn't, however it was restrained, it wasn't restrained at that place on the pistol where our thumb and forefinger would normally hit the pistol. Isn't that correct?
No.
All right.
Well, and again, it was, you asked him right, and he said no. So, Mr. Kaiser, I think the jury understands, but so the record is clear. If you can,
I'll do it a different way.
Thank you.
There was no place where, as your gun was fired 10 times, that the pistol was being held by some restraint at the place on the pistol that would normally hit the webbing between our forefinger and our thumb.
That's correct. As I mentioned earlier, the objectives were to have enough pressure on that firearm to chamber properly. And when there was not enough pressure, or the position of the grip,
This is fine.
it did not chamber correctly.
But, and I appreciate that. And what I want to be sure I understand, because I heard you say that you changed things because you hadn't gotten the desired results. Is that right?
That's correct.
All right. So in your method, you had desired results you were trying to achieve. Is that correct?
I had two objectives.
Right. But you, in your mind, those were desired results, correct?
Correct.
Detected as repetitious.
Overruled. Answer stands.
And when you talk about pressure, what you're talking about is how tightly, in the facts of our case, how tightly Chase Fleischauer would have been holding that pistol if it were as you posit that he was holding it himself. Is that correct?
Could you rephrase that question, please?
The pressure that you're talking about is pressure that comes from the person holding the pistol. Is that right?
Correct.
And if it were to be, as you've put it up there, that Chase was holding the pistol himself, he would have had to have held it tightly enough for three things to happen. One, the trigger to be pulled all the way back to fire the gun, correct?
Correct.
Two, for the now expended shell casing to eject from the ejector port of the pistol, correct?
Correct.
And three, for the next unfired cartridge to come up and lodge itself in the chamber ready to be fired. Is that correct?
That's correct.
And we know he held it that tight because all three of those things happened, correct?
A lot of variables I'm not sure of, but that is a possibility.
So in other words, you're telling us you're not aware that the gun fired an expended round ejected from the pistol and another round loaded into the pistol ready to fire. You don't know that?
I am aware of that.
Now, the static uniform firearm testing apparatus was made of metal and glass, is that correct?
Correct.
Or plastic? Was it like a plastic or?
It was a Lexan bullet-resistant plastic.
Okay. None of it moved after the shot was fired in any of your scenarios, is that correct?
That's correct.
Do you have any basis upon which to believe that if it was as you posit it to be, that Chase shot himself, is there any basis upon which you believe that Chase didn't move after he was shot?
I don't know if I have an opinion.
I'm not asking your opinion. I'm asking whether you have.
Object, Your Honor, he interrupted the witness.
Well, no, he said I don't have an opinion, so what's the next question, Mr. Kaiser?
I'm not asking if you have an opinion. I'm asking you if you have a basis upon which to believe that by having this static uniform cuneiform firearm testing.
Static human form firearm testing.
Human form. Oh, I thought you said cuneiform.
Sorry.
No problem. Is there any basis in the facts of this case upon which you concluded that it was an accurate reproduction of this event to have your static human form firearm testing apparatus not move after the shot was fired?
The scope and the objective of my testing focused solely on the energy of the gun when it was fired and the distance that it traveled from that energy and the condition of the readiness of the pistol where it landed. Does that help?
It does help me ask my next question, which is, that focus caused you to pay no attention to what, if any, effect the falling away of the human body from the shot being fired would have on where the gun did or didn't go.
That variable was not tested.
And you don't dispute with me, do you, that had Chase shot himself, as you posited it, he still yet would have fallen away from the shot being fired?
Again, with the variables in question here, I couldn't comment on that.
And nor could you account for it in your testing?
Correct.
In fact, when you talked about the trial and error of trying to get the pistol to do what you wanted, that's what you said. It was trial and error to try to get it to do what I wanted, right?
Again, the objective was to have the firearm eject the spent casing and load the inert round or the next cartridge.
So that was the objective, not to try to reconstruct the scenario had it happened that Jace shot himself, right?
Objected that as an ambiguous question.
Do you understand the question, Mr. Burton?
I guess I'm sorry, I'm not exactly sure where you're going with that.
Thank you.
Given what you've said your limited purpose was, that is not the same thing as saying my purpose was to reconstruct what would have happened at that kitchen island had Chase shot himself, right?
Correct.
Am I right?
Correct.
All right. Showing you Exhibit 39. Have you seen photographs of the scene before now?
I have.
So that scene's not, the scene, sorry. The scene shown in Exhibit 39 is not one unfamiliar to you, but based on looking at photographs.
Correct.
All right. Has to republish to the jury.
Granted.
Thank you. Here on what is the left side of the island, what appears to be there?
I'm sorry, I can't make that out other than the stool you're referring to.
I'll bring it up so you can see
Okay.
it. I just want to leave it up long enough for the jury to see what I'm talking about when
Sure.
I bring it to you, okay?
And folks, are you able to see it, or would dimming the lights help? You're able to see? Okay, thank you.
All right. So I'm pointing to this place on your left of the island, above the stool that's knocked over. What do you see there? A stool. Thank you. Now, how did you come to decide how you were going to construct the table that was in front of your device?
The dimensions are you referring to, or?
The design of it in general.
It was an approximation of what a center island in a home generally is.
You had been in the home because you helped him move in, right?
I did. I was.
The island was there when you helped him move in, is that correct?
Correct.
Showing you Exhibit 27. Could you tell me, as you look at this to your right, how is the island constructed?
It looks like there's 2 levels.
Asked to republish to the jury?
Granted.
Thank you. So as we look at the island, there is a counter where one would sit at the stool. Is that correct?
Correct.
And then there's a lower counter where, for instance, someone might serve from if people were on
Yes.
the counter.
Yes.
Is that right? The table that you had set up in front of your human form device had only one level, is that right?
That's correct.
Device also had, your human form device also had arms on it that were kind of bent at the elbows, is that correct?
That's correct.
And they were bent at the elbows and leaning on whatever the table thing was that you had there, is that right?
Yes.
What facts did you have that you relied on to conclude that that was the position to put your human form device in?
Those 2 positions were just 2 variables that I selected.
So there were no facts that you were aware of from any photographs in this case that showed Chase Fleichauer in that position, is that correct?
That's correct.
One of the, do you remember using earlier the phrase extraneous force?
Yes.
So one of the extraneous forces that you were trying to not account for would be the extraneous force on the pistol as it leaves the person's hand, correct?
That was only in reference to the trigger.
Well, the person's finger would be in the trigger. The person's thumb would be wrapped around the backside of the gun.
Mm-hmm.
So far, so good?
Yes.
Right. So then, if in your scenario, when the gun is fired and the trigger finger lets go, that has to happen inside the trigger guard, correct?
I don't have any knowledge of how that trigger was pressed.
Was it pressed with a piece of acrylic on the morning of April 14th?
On my testing, yes, it was very much with the acrylic that I set up in the test.
But your tests, 10 of them, were designed to try to show us your perception of what would happen if a person were to hold that gun in their hand with their trigger finger and with their thumb in the back of the gun, pull the trigger and shoot themselves with it, right? Or not?
Again, the objective there was simply the force of the gun and the recoil that it generated to demonstrate how a 18, 19-ounce gun, pound and a quarter gun, firing a projectile with a force of over 300 foot-pounds of energy has the potential to travel a certain distance.
So it really wasn't designed to show us.
It was not designed to replicate any crime scene or anything of that nature. With the information that I had available through Mr. Gray, that's what I came up with.
I'm a little confused about the inert bullets. I understand the reason why you did it. I totally get that.
Absolutely.
But I'm a little confused about exactly what you did. When I saw inert, I was thinking of plastic. So why don't you explain to me again what you were doing with the inert bullets? Because then I want to talk about the weight.
Okay.
Go ahead.
The inert round that we're referring to, inert as in unable to be fired, that could be a plastic round. Often in the industry it's referred to as a snap cap. Either way, it's a round, a cartridge of ammunition that is constructed to have similar characteristics to an actual live round. In this case, I was able to remove the bullet, the powder, and primer to render this an inert round.
Thank you. And that's what I want to focus on. So if it doesn't have gunpowder in it, it's not going to hit. It's not going to fire if the firing pin hits it.
Correct.
Okay. And you said you load your own ammunition, is that what you said?
That's correct.
So my question is, once you had the gunpowder out of the empty shell casing, did you put the bullet back into it?
I did.
All right. Approximation of what the weight difference is with and without the gunpowder?
20 grains.
On occasions, when you pulled the string from the acrylic, the pistol came towards you, is that correct?
What you saw in that video was the force and reaction of the firearm that the pistol displayed.
And on occasion, as we watched the 10 different tests, the pistol came towards you where you were pulling the string, right?
Some shots there were.
One of the things that you described to us earlier was that there is a portion of the trigger of the PT-709 that is sort of like a safety.
It is a trigger safety.
Would it be fair to say that if a person were pulling that trigger, they would be alerted by that safety that they're in fact pulling the trigger?
The pressure to overcome the trigger safety would not be recognizable to somebody that didn't know what to look for.
Okay. For your acrylic to work, the trigger would have had to have been pulled back past that safety. Is that correct?
The acrylic engaged the trigger safety.
Oh, it went that high up on the
Yes.
trigger?
Otherwise, the trigger would not have been able to be pulled.
So when you were ready to pull the acrylic out, that last safety on the trigger itself was already engaged. In other words, it was already pushed back towards the handle.
Correct.
The angles at which you positioned your human form device, sorry, different question. The choices of the angles of the human form device had no more of a basis in the facts of this case than your choice to have the device with its elbows on the table. Is that correct?
It was arbitrary. Yeah, there was no.
And the stool itself looks like one of the ones that's in the pictures from the house. Is it one of the stools from the defendant's house?
It is.
Oh, and the carpet also was actually from the defendant's house. Is that correct?
Judge, that's 2 more times that we've had defendant mentioned. I don't know.
I'm sorry, Judge.
He's been sorry many times.
Well, Mr. Gray, be seated. Let's continue, Mr. Kaiser.
I'm actually done, Judge. Thank you. Yep.
Mr. Gray.
I just have one. Mr. Burton, you mentioned at one time in your cross-examination that you did some research on this, all right?
Correct.
Did you find any research, strike that, research in an area means you're looking in journals and things of that nature, for other people that tested the recoil, correct?
That's correct.
Did you find any, in your research, any testing regarding the recoil of a pistol and how far it would go if loosely held?
Neither in online documentation nor in face-to-face with other experts in the industry was anyone able to give me any indication of what that firearm would do while loosely restrained. It's just not a normal function of that firearm.
Thank you, that's all I have.
Nothing
you.
else.
Mr. Kaiser, thank you. Stand down, Mr. Burton. Mr. Gray, do we have another witness?
Yes, a brief one,
Thank you.
hopefully. You can sit in the courtroom now, Your Honor, is that,
Pardon?
can Mr. Burton sit in the courtroom?
No objection.
Thank you. Without objection. Sir, if you'll come up towards me, please. And if you'll raise your right hand for administration of the oath.
Do you swear that the testimony you're about to give in this matter shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. If you'll come over and have a seat in the chair. And that microphone arm you can swing out. And then if you'll swing it back in, please. Mr. Gray.
Thank you, Your Honor. Could you state your name, sir?
Stephen, Steven, Tredal, Tredal.
And are you a medical doctor?
Yes,
How long have you been a medical doctor?
since 1980. Yep.
And I show you Exhibit 326. Can you identify that doctor?
Yes, that's my curriculum vitae.
Okay. Offer 326.
If I could see it, that'd be great.
I've seen it before.
Counsel.
Thank you.
Any objection, Mr. Kaiser?
No.
Received.
And what is your specialty, or was your specialty withdrawal? Are you presently retired?
Semi-retired, I guess is what
does
it's.
that mean?
It means I'm not totally retired. My career is emergency medicine. I'm a board-certified emergency medicine physician, but I retired or left the active practice in the emergency room approximately 5 years ago, 5+ years ago. But I continued to practice in other forms of practice and maintain my certification in emergency medicine which I recertified in 2016, 2 years after I actually moved out of the emergency room.
And as a emergency medicine specialty, is that what you,
Yes,
you've seen many injuries, would that be fair?
that would be fair.
And were you hired a couple of years ago almost to go to the Ramsey County Medical Examiner's Office to view the body of Chase Fleichauer?
Yes.
And what were you doing? Why were you asked to go there?
You had asked me to go there to review all the external findings that were reported when the autopsy was done at the medical examiner's office by the forensic pathologist, to verify as a second look that that description in the autopsy protocol was accurate, involving all the external findings or injuries.
And were you able, through the autopsy or doing Chase Fleischauer's body, to determine the cause of death? The autopsy, what did it show?
Yes, well, the cause of death, both an external exam and also the report, showed a bullet wound to the forehead, which would externally be the only explanation for the cause of death.
Okay, so it would be a bullet, gunshot to the head?
Correct.
But you were asked to go there to look at the other external injuries, correct?
Correct.
And the external injuries that you reviewed, were they consistent to as to what was on the autopsy?
Yes.
And in your opinion, to a reasonable degree of medical certainty, could those injuries, strike that, did you see any serious external injuries?
Objection, relevance of seriousness.
Sustained as to form.
Can you describe to the jury the injuries that you observed?
Well, all or most of the injuries I observed appeared to be fairly superficial and minor, the kind of injuries that wouldn't typically involve any serious injury to result in a serious condition or certainly death.
And the injuries that Chase Fleischauer did have to a reasonable degree of medical certainty, could those injuries been caused by two intoxicated persons wrestling on a hard floor?
Objection to the relevance of the persons intoxicated to the opinion.
Sustained as to the form of the question.
Well, if one individual had approximately a .278, and the other individual had a .19, 9 hours later, would you consider those two individuals intoxicated?
Yes.
And if those two individuals were wrestling with that, would you, in your opinion, to a reasonable degree of medical certainty, would those injuries on Chase Fleischauer's body be consistent with wrestling on a hard floor?
Objection, foundation for the word wrestling in this witness's mind.
Okay.
Mr. Gray, firm
Sure.
it up.
Let's go back to your younger days. Were you a wrestler?
It's a long way.
Were you a wrestler?
Yes.
And did you wrestle in high school?
Yes.
And you know what high school wrestling is?
Yes.
And in addition to that wrestling, I should have clarified, are you familiar also with pro wrestling, where some people say it's fake and people jump off ropes and that?
Yes.
So I'm going to first deal with the high school wrestling. There's mats below you, correct?
Yes.
And in wrestling on a floor without the mats, would the injuries in this case that you reviewed be consistent with wrestling on a floor without mats and having the blood alcohol that I've cited to you?
Objection, no foundation. The wrestling that occurred for which there is foundation happened on mats?
I'm not talking-
Well, overruled. You can answer the question, Doctor, if you understand it.
The answer is yes.
And tell the jury what petechiae is.
Petechiae are small pinpoint hemorrhages where a small vessel is ruptured and appears on the skin as typically like a small red dot.
I guess when an individual has consumed a substantial amount of alcohol, 278 or 3.3, does that alcohol thin their blood at all?
Can
And so your blood would be thinner with all that alcohol in it?
have an effect, yes.
And would that have an effect on somebody getting petechiae where your blood's thinner?
Yes, and it also can alcohol affect the liver where your clotting substances are manufactured.
What does that mean?
That means people who drink a lot oftentimes don't clot as well because of their liver function secondary to damage from alcohol.
And petechiae, to a reasonable degree of medical certainty, could that be caused by somebody straining themselves in a wrestling match or any type of match like that?
Yes?
Thank you, doctor. That's all I have.
Thank you. Mr. Kaiser?
Who was present when you examined the body?
There was occasionally one of the morgue attendants who came in and out of the room.
What day was that?
It was sometime after the 15th of April of 2018. Then a couple days of that, I believe.
Had Chase Fleischauer been more or less put back together after the autopsy when you examined him?
Yes?
So you didn't see the fractures in his skull since he had been put back together, is that correct?
Correct.
Object to that, Your Honor, is outside the scope of the direct examination.
But it's cross-examination overruled.
In your work as a emergency medical physician, where was that practice?
Well, it was in several areas. Very early on, it was in a number of the hospitals that have since closed in St. Paul. But then for approximately 10 plus years, I was the medical director of emergency medicine and practiced emergency medicine in what became Health East. And then the subsequent approximately 22 years, I was a medical director, emergency medicine, and practiced primarily at United Hospital in St. Paul.
When you were medical director, did you still see patients on an emergency basis?
I saw patients regularly on an emergency and a shift basis.
Are you familiar with the term blunt force trauma?
Yes?
And is it fair to say that blunt force trauma happens during a fight?
Yes?
Medically speaking, how, if in any way, are the external injuries on Chase Fleischauer any different than those that resulted from a fight?
They're consistent with being in a fight. or in any other way being struck by, falling on, or hitting something.
Or thrown down?
That could do it.
When was the last time you yourself actually performed an autopsy? In other words, you were the doctor responsible for doing the autopsy and concluding as to both cause and manner of death?
I did that, I have to refer to my CV probably, but at Ramsey County Medical Examiner's Office when I was a resident in pathology and also was a deputy medical examiner and did forensic autopsies at that center.
Yep, I'm just asking when it was.
1982 to 84.
Did you do 5,000?
No.
There's a, based on your experience in emergency medicine and other aspects of your experiences that you've described to us, to a reasonable degree of medical certainty, could a person get petechiae in and around their eyes from being held under another person's arm by the neck and having that other person's arm via their armpit around their neck?
Object to that, Your Honor, there's no evidence of that in this case.
I can approach and tell you what I think it's based on.
Well, and again, counsel, ladies and gentlemen, this is a hypothetical question. You're to consider it only if the underlying facts are proven. So with that understanding, Mr. Kaiser.
Thank you. Is there a hold? The petechiae result from pressure being put on the person, is that correct?
It can, yes.
So to reasonable degree of medical certainty, could petechiae in a person's eyes result from the person having their head in the front or back of another person's armpit and the arm, shoulder, and arm coming down on their neck?
Yes, what happens, one of the things that can happen to cause petechiae is when you put pressure on the veins that come from the head down through the neck so that you stop the ability of the blood to empty out of the head. At the same time, blood is being pumped in from the arterial vessels that aren't compressed. Eventually enough pressure can be built up that the little vessels can rupture or leak and then form petechiae. And the eyes are very more sensitive to that than most of the other soft tissues in the head.
No further questions.
Thank you. Mr. Gray, redirect. Thank you. Stand down, Dr. Tredal. Counsel, do you want to approach? Ladies and gentlemen, we are going to adjourn for the day, adjourn for the week, so you get out early on Friday. Again, folks, you have 2 days to basically honor, respect this court's admonitions that you've heard throughout the week. I always find it becomes a little more challenging with length of time because of your exposure to folks on a casual basis on a weekend. I don't think it's probably a surprise to friends or family that you're on this jury. I may be wrong, but it wouldn't surprise me that that is a given, which again, potentially makes you a target for questions and observations and comments. Similar to a juror who shared during voir dire, if you're faced with those casual comments or questions, you have to excise yourself. You cannot participate, listen to, nor be engaged in. Likewise, you've heard testimony about experiments and other things that have been done in this trial. You are not permitted, clearly, to conduct your own experiments or to do any research or try to fill in any gaps or other materials that you think might be useful to you when considering this particular case. Now, I emphasize all that, folks, and you don't know how critical that is to this case as well as to your participation as jurors. So with that said, we will see you Monday morning, again, that 8 o'clock to 8:15 hour. We've been extremely conscientious in starting on time in this case, and that speaks well of you and again, your timeliness. So with that said, again, leave your notes with the bailiff. We'll collect them, secure them, return them to you on Monday morning. Have a good weekend, and we'll see you Monday. Thank you.
Excuse me, Your Honor, could I go for one?
Sure.
This-
Ladies and gentlemen, also, as you know, this matter is being recorded, and someone has told me live streamed, as well as potentially able to access through what has been recorded in other days and re-shown. Again, I don't know if family or friends are paying attention, watching, but again, it goes to this whole sense of don't talk to anyone about what they've seen, heard, read, or otherwise, and clearly you will not be accessing through the internet or otherwise any of these recordings or other information that may be currently in social media or on the internet. Thank you. Now we'll see you on Monday morning.
All rise.
Okay, but we're reasonably safe to conclude we'll be done with evidence hopefully on Monday, subject to the state's rebuttal.
Sorry, I apologize, Judge. We do have rebuttal witnesses. My hope and prayer would be that we'd be finished on Monday.
Which sets us up, as I was saying, for hopefully still doing closings at some point on Tuesday and instructions. Back on, Mr. Kaiser, you wish to memorialize something for the record outside the presence of the jury?
Yes, I do, Your Honor. I didn't want the court to believe for 1 second that I would knowingly and purposely ignore the court's order. The record does not reflect the following facts that if this were to become an appellate issue, that it should reflect. I've been a lawyer since 1978, and I've been a prosecutor the entire time. I quit doing appellate practice in Chicago in 1982 and have been a trial lawyer since then. I stopped counting jury trials in the 1990s because there was a lot of them. I understand the court's ruling and understand why the court is doing what the court is doing. And in fact, on behalf of victims, I appreciate very much when prosecutors are forced to have to call the victim by their name and not by the word victim. I understand the same accommodation should be provided to the defendant. I just ask this record to reflect that whatever it is the defense has accused me of, and they have every right to accuse me of whatever they choose to, and this is not a criticism of the court's ruling at all. It is simply a fact that in my whole career, I've never been forced to not ever use the word defendant and face opprobrium from the court, which is appropriate. You've entered an order, and it is expected that I follow it, and I totally understand that, Judge. It's just that when I'm constructing my questions, it's a thing I have never had to factor in. I apologize deeply to the court. I hope the record reflects that this is not anything intentional on my part. I understand I could be accused of it, which is why I want to make a record of it. Because if it is something that comes up on appeal, I want the record to reflect my experiences and my deep appreciation of what the court's trying to do, and that I will make every effort to continue to abide by the court's order.
Thank you, and I have the utmost respect for the attorneys who have been participating in this trial, round two, albeit I, too, Mr. Kaiser, have been practicing since 1978 and have been on this bench now just short of 26 years. And at least I think I am known to be a judge who expects in criminal cases defendants to be referred to by name. I would trust Ms. Ellenwood would attest to that in any trial that she's conducted in this courtroom. And so it is my practice since 1994 to ask that we refer to victims, to defendants, to others by their name as opposed to a title or some other type of reference. And so I note what you said, Mr. Kaiser. I will find that it was not intentional for purpose of any appeal, but rather, again, based on your experience as well as your practice as an attorney for long-standing in this state. But, as I said, it is my requirement in any criminal case that as best we can, we refer to defendants by name, we refer to victims by names as opposed to putting a label on them. But I also, in those same pretrials, generally note, I don't know if I did specifically in this case, that I understand there may be the occasional slip up or miscue or misstatement. So I think we've made enough of a record today, and we'll see everybody Monday morning by 8 o'clock. Mr. Gray.
Your Honor, I've been practicing since 1970.
I'm not sure if any of us,
That's fine.
thank you.
Thank you, Your Honor.
See everyone Monday. And I was going to say, because Ellen wasn't born yet.